There is a document that gets sold to families as the solution to almost every estate planning problem. It avoids probate. It protects privacy. It prevents family conflict. It keeps the government out of your parents' money. It costs a few $1,000s and it fixes everything. That document is the Revocable Living Trust. And some of what you just heard is true, but not all of it. And the gap between the true parts and the parts that are being oversold is where families make expensive mistakes, sometimes by not creating a trust when they should, and sometimes by creating one and believing it does things it simply does not do. By the end of this video, you will have a clear, honest picture of what a revocable living trust actually is, what it genuinely does well, what it cannot do, who it makes sense for, who it probably does not make sense for, and what questions to ask an elder law attorney before you decide. This is not a sales pitch in either direction. There are situations where a revocable living trust is one of the best tools in elder planning. There are other situations where a simple will and the right beneficiary designations accomplish the same goals at a fraction of the cost. Understanding the difference is the whole point. This content is for educational purposes only. It is not legal or financial advice. For your specific situation, consult a certified elder law attorney. You can find one at nayla.org. Let's start with the basics. What a revocable living trust actually is. A revocable living trust is a legal document you create during your lifetime. That is what living means, in which you transfer ownership of your assets into the trust and name a trustee to manage those assets according to your instructions. In most cases, the person who creates the trust, called the grantor or settler, also serves as the trustee during their own lifetime. This means you create the trust, you transfer your assets into it, and you remain in full control of those assets. You can buy and sell property, change investments, update the beneficiaries, add or remove assets, and even dissolve the trust entirely. That is what revocable means. It can be changed or undone at any time while you have capacity. When the grantor dies or becomes incapacitated, a successor trustee, someone named in the trust document, steps in. This successor trustee manages and distributes the trust's assets according to the instructions in the document, without any court involvement. That last part is the core value proposition of the revocable living trust. It operates outside the court system, both during incapacity and at death. Now let's look at what that actually means in practice. The 4 genuine benefits. The 4 genuine benefits. The first and most significant benefit is probate avoidance. Probate is the court-supervised process of validating a will and distributing a deceased person's estate. It is a public proceeding, it takes time, and it costs money. How much money? According to research compiled from state statutes and attorney fee data for 2026, probate typically costs between 3 and 7% of the gross estate value. On a $500,000 estate, that is $15,000 to $35,000 in fees, attorney fees, executor commissions, court costs, publication requirements, and appraisal fees, all paid from the estate before a single dollar reaches the heirs. The timeline is not short either. Simple, uncontested estates typically take 6 to 12 months. Complex or contested estates can run 2 years or longer. During that period, the estate is essentially frozen. Heirs generally cannot access the assets until probate closes. Assets held in a properly funded revocable living trust bypass this entirely. The successor trustee distributes the trust assets according to the trust's instructions, typically within weeks or a few months, without filing with any court, without a public record, and without the associated fees. That said, one critical point that is often glossed over: the trust only avoids probate for assets that have been properly transferred into the trust. This is called funding the trust, and it is the step that many families either skip or do improperly. A revocable living trust that has been created but not funded, meaning the house, the bank accounts, and the investments are still titled in the individual's name rather than the trust's name, does not avoid probate. The document exists. The protection does not. The second benefit is privacy. Probate is a public process. When a will is submitted to probate court, it becomes a public record. Anyone can request a copy. The assets, the debts, the beneficiaries, the family dynamics, all of it becomes accessible to anyone who wants to look. A revocable living trust is never filed with any court. The terms of the trust, the assets it holds, and who benefits from it remain private. For families with significant assets, complex family situations, or concerns about unwanted attention from creditors or others, this matters. The third benefit is multi-state property. If a parent owns real estate in more than one state, a home in Florida and a vacation property in North Carolina, for example, their estate may face ancillary probate in each state where property is located. That means separate court proceedings, separate attorneys, separate fees in each jurisdiction. A revocable living trust that holds those properties avoids the need for ancillary probate entirely because the trust, not the individual, is the owner of record. The fourth benefit is incapacity planning. This is the one that matters most in the context of aging parent planning specifically. When the grantor becomes incapacitated, whether from dementia, a stroke, or another condition, the successor trustee has immediate authority to manage the trust's assets. No court petition, no conservatorship proceeding, no legal delays while bills pile up. This mirrors what a durable financial power of attorney does, but with a structural difference. The trust holds the assets in its own name, so the trustee's authority is built into the legal title rather than dependent on a third party, is a bank, a financial institution, honoring a separate document. In practice, a well-drafted durable POA is often sufficient for incapacity planning. But for families with significant assets or complex financial situations, the trust provides a more self-contained structure that can be easier to administer without institutional friction. What a revocable living trust cannot do. This is the part of the conversation that is most often left out, and it is where families sometimes develop a false sense of security. A revocable living trust does not protect assets from Medicaid. This is probably the most common misconception in elder planning. Many families create a revocable living trust, believing that once assets are inside the trust, they are protected from Medicaid's asset rules and from nursing home costs. They are not. Because the grantor retains full control over the trust, they can change it, dissolve it, pull assets out at any time. Medicaid treats the trust's assets exactly as if they were still in the grantor's name. They count against Medicaid eligibility. Transferring assets into a revocable trust does not create any distance between the grantor and those assets in Medicaid's eyes. If Medicaid asset protection is the goal, a different and much more complex tool is required, typically an irrevocable Medicaid trust, which permanently removes the grantor's access to and control over the assets. This is a significant planning decision with its own trade-offs, subject to the 5-year look-back period, and requires careful guidance from an elder law attorney. A revocable living trust is not a substitute. A revocable living trust does not reduce estate taxes. Because the grantor retains full control, the trust's assets are included in the taxable estate for federal estate tax purposes. There is no estate tax advantage to a revocable living trust. Federal estate taxes in 2026 apply to estates exceeding the current exemption threshold. For 2025, it was approximately $14 million per individual, and the elevated exemption is subject to potential changes, which means the vast majority of families are well below the threshold regardless. But for those who need estate tax planning, a revocable living trust is not the vehicle. A revocable living trust does not protect assets from the grantor's creditors. Because the grantor can revoke and access the trust at any time, creditors can reach the trust's assets during the grantor's lifetime. If liability protection from creditors is the goal, but that is a very different planning tool with very different trade-offs. A revocable living trust does not eliminate the need for other documents. A trust still needs what is called a pour-over will, a companion document that directs any assets not transferred into the trust during the grantor's lifetime to pour over into the trust at death and be administered according to its terms. That pour-over will goes through probate, which is why funding the trust properly during life matters so much. The trust also does not replace a healthcare proxy or an advance directive. Those healthcare documents are essential regardless of whether a trust exists. Who a revocable living trust typically makes sense for. With the genuine benefits and the limitations both on the table, let's talk about which families are typically good candidates for a revocable living trust. Families where a parent owns real property are almost always worth considering. If the estate includes a home, and for most families it does, that home will go through probate without a trust or another avoidance mechanism. Given the cost and timeline of probate in most states, and given that the home may represent the largest single asset in the estate, avoiding probate on the real property alone can often justify the cost of the trust. Families where a parent owns property in more than one state should almost certainly consider a trust, given the alternative of multiple probate proceedings in multiple jurisdictions. Families who value privacy, for reasons of family complexity, business interests, or simply a preference not to have their financial affairs in a public record, have a genuine reason to prefer a trust over a will. Families with significant non-probate avoidable assets, beyond what can be handled through beneficiary designations and pay-on-death accounts, may find the trust provides a cleaner administrative structure, and families where a parent has concerns about incapacity management, where the trust's built-in successor trustee structure is preferable to relying solely on a durable POA, may find the trust provides a more robust solution, a rough general guideline used by many practitioners. If a parent's total assets, including the home, exceed approximately $100,000, the cost-benefit calculation for a revocable living trust often becomes favorable. Below that threshold, simpler tools may accomplish the same goals at lower cost. A revocable living trust probably does not make sense for. A trust is not the right tool for every situation. If a parent's estate is relatively simple, a modest home, a few bank accounts, retirement accounts with named beneficiaries, the same probate avoidance goals may be achievable through simpler mechanisms: joint tenancy on the home, pay-on-death designations on bank accounts, and transfer-on-death registrations on investment accounts. These tools are free or nearly free to set up and require no ongoing administration. In many cases, a properly constructed set of beneficiary designations and title arrangements accomplishes everything a revocable living trust would accomplish at a fraction of the cost. If the primary concern is Medicaid planning, protecting assets from nursing home costs, a revocable living trust provides no help. The planning conversation in that case should be about Medicaid-compliant tools, the 5-year look-back, spend-down strategies, irrevocable trusts where appropriate, and the spouse's protected assets. A revocable living trust is not part of that solution. If the parent's state has a simplified or streamlined probate process, some states have small estate affidavit procedures that allow simple estates to bypass full probate at very low cost. The relative benefit of a trust may be smaller than in a high-cost probate state like California. And if the trust is created but not funded, the assets are never retitled into the trust's name. It provides essentially no benefit at all, while still carrying the upfront cost of creation. The cost and what it covers. The cost of